Hello everyone, welcome back to our Learning Legal English through Case Laws series. In this video, we will study Case Law No. 33/2020/AL about regarding a person allocated land by the state and got the land managed and used stably and permanently by another. Case Law No. 33/2020/L, the only case of regarding a person allocated land by the state and got the land managed and used stably and permanently by another. Including 5 parts: Part 1, Source of the Case Law; Part 2, Overview of the Case Law; Part 3, Content of the Case; Part 4, Assessment of the Court; Part 5, Rules. This case law was approved by the Council of Judges of the Supreme People's Court on February 5, 2020 and published under Decision No. 50/QDCA of the Chief Justice of the Supreme People's Court on February 5, 2020. The Cassation Decision No. 34/2018/DSGDT on June 26, 2018 of the Committee of Judges of Collegial People's Court in Hanoi on the civil case of requesting the return of house and land in compensation when the state recovers land in Hung Yen Province between the petitioner Ms. Bui T.P., Mr. Lunak T1 and Ms. Lu T-Ton X and the defendant Mr. Lunak T2 and 06 persons with the related rights and obligations. The plaintiff, Mr. Bui T.P., Mr. Lunak T1 and Ms. Lu T-Ton X, represented by Mr. Bui T.P. The defendant, Mr. Lunak T2. Part 2, Overview of the Case Law. Case Law Situation. The individual allocated land by the state but did not use and got the land managed and used stably and permanently by another. In the course of land use, this person has embellished the land, built a stable house, declared and was granted a certificate of land use right without any opinions from the land grantee. Legal resolution. In this case, the court should not accept the request to reclaim the land use right. Key words of the case law. Lawsuits over the land use rights. Get the land managed and used stably and permanently by another. Built a stable house. Register and declare on the land use right. Part 3. Content of the case. In the petition and in the procedure, the plaintiff Mr. Bui T.P., Mr. Lunak T1 and Ms. Lu T-Ton X, represented by Mr. Bui T.P., presented. In 1973, Mr. Yu went back to his hometown to apply to the People's Committee of Ward D1, District P, Hung Yen Province for a land with the area of 1,079 square meters. In 1976, Mr. H went back to the hometown to build a house with 3 compartments, 1 attic, and the construction included kitchen, well, bathroom and toilet on that land plot so that Mr. Yu and Ms. T, who had been retired, would stay. Mr. Yu and Ms. C stayed there for a while, then they moved into a village at which Ms. T's parents' home and the land located. In 1977, Mr. Lunak C1, a younger brother of Mr. Yu, borrowed that house and land plot so that his son Mr. Lunak T2 could stay. In 1985, Ms. B got married with Mr. H while Mr. Yu, Ms. T, and Mr. H was living at 53C, Ward D, L City, Lang Son Province. In January 22, 1994, Ms. T passed away in Lang Son Province and so did Mr. Yu in December 20, 1995. They both died without a testament. According to Ms. P, before Ms. T died, she had handled a paper showing the commune's allocation of land to Mr. U in Village D in 1973 over to Ms. P. However, in 2008, due to a historic flood in Lang Son, Ms. P's house flooded, all the personal documents were damaged. In 2008, Mr. LUhenT T2 left for Lang Son to meet Mr. T and request him to establish a power of attorney so that Mr. T2 could receive the compensation for the state's land acquisition to construct the road 38B. In June 2009, Mr. H died without a testament but told Ms. B to return to her hometown to reclaim the house and land which had been borrowed by Mr. T2. Ms. P and her children requested Mr. T2 family to return the whole house and land plot and repay the compensation of 398,638,000 VND for the state's land acquisition in 2008. The defendant Mr. LUhenT T2 presented, the land plot managed and used by his family was the land which his father Mr. LUhenT C1 asked Mr. LUhenT U, Ms. C1's elder brother, to apply to be granted under Mr. U's name in 1974. In reality, his father was the one who directly received the land. In 1975, his father agreed with him and his wife on building a house on that land. Since they lived on the land until Mr. U, Ms. C, and Mr. H died, Mr. U family had not been recognized as his own and returned to build any house in that land plot. The house and assets on the land were built and embellished by him and his wife. In 1998, he declared the land use right under his name. In 2008, when the state recovered the house to expand the Road 38B, his family was compensated an amount of 300 million VND. Because his name was not shown in the documents, the People's Committee of D1 Commune asked him to obtain a commitment of the person named on file 299. He went to Lang Son to meet Mr. H and request him to establish a commitment. Mr. H established a written commitment on April 10, 2008 on confirming that the land plot Mr. U was granted on 1974 would be allocated to Mr. T2. His family had had no idea from the past to now. He did not accept the entire request of Mr. P and his mother. According to the People's Committee of D1 Commune, the land plot owned and used by Mr. T2's family was shown on the map 299 made in 1981, with an area of 1,073 square meters at plot 117, map sheet 15. In the Charter 1986, on page 128, it was shown that the landowner was LUhenT U1. The People's Committee of D1 Commune verified and concluded that Mr. LUhenT U1 was from Village D, but not the owner of this land plot. It was exact that Mr. LUhenT U was the owner, according to the cadastral map of Commune D1. Completed in December 1998, the land plot managed and used by Mr. T2's family included 04 plots, lot number 269, T, 574.4 square meters, plot 251, ponds, with an area of 261.2 square meters, lot number 286, pond, area 152.9 square meters, plot number 301 with an area of 149.1 square meters, which was the corridor land of Road 38B. The total area of the plots and corridors was 1,177.6 square meters. According to the list made in 1998, on the page 86 and 87, the above land plots were listed with the landowner LUhenT T2. Mr. Tran Van H1, Ms. Tran Tkim H2, Mr. Tran Van L, Mr. Tran Van N1, Ms. Tran TM and Ms. Tran TG presented. They did not know about the origin of the land plot, but since they were born and raised, their father had been cultivated and used that land. In 1997, Mr. C1 was granted the Certificate of Land Use Rights. In 2009, Mr. N was gifted the land plot by Mr. C1 and was granted the Certificate of Land Use Rights. Thus, they did not agree with Ms. S's requests. In the civil first instance judgment number 01/2015/DSST dated March 31, 2015, the People's Court of Fu-Siu District decided 1. Accepting a part of the petition of Ms. Lu Titan X and Mr. LUhenT T, Ms. Bui TP had no rights related to the legacy of LUhenT U and Bui TT. 2. Mr. LUhenT T2 and Ms. V were assigned to manage and use according to actual measurement data on August 8, 2014, which is 990 square meters. The residential land was 816 square meters, pond land was 174 square meters, with attached diagram. Mr. LUhenT T2 and Ms. Don TV were obliged to register the assigned land use right at the competent authority, in accordance with the land laws. 3. The houses, constructions, trees and crops on land plots were owned by Mr. T2 and Ms. V. 4. Forcing Mr. Lunak T2 and Ms. Don T pay Ms. Lutitan X and Mr. Lunak T1 the value of the inheritance that Ms. X and Mr. T1 was inherited from Mr. Lunak U and Ms. Bui TT, which was 191,864,200 VND. On April 15, 2015, the defendant Lunak T2 appealed a part of the judgment. At the Civil Appellate Judgment No. 25/2017/DSBT dated September 28, 2017 of the People's Court of Hungyen, it was decided that 1. Accepting a part of the petition and appeal of Ms. Lud Titan X, Mr. Lunak T1 and Ms. Bui TP, other name, Bui T Hung P. 2. Assigning to Mr. Lunak T2 and Ms. Don TV land area 01/621.2 square meters dated March 31, 2015 number 15 of map 299 established in 1981 at Village D, Commune D1, District P under the name of Mr. Lunak U. Assigning to Ms. Lud Titan X, Mr. Lunak T1 and Ms. Bui TP, another name, Bui T Hung P, an area of 369 square meters, including 174.2 square meters of pond land, at land plot number 117, map sheet number 15, map 299 established in 1981 at Village D, Commune D1, District P under the name of Mr. Lunak U, and the property on the ground was a building with 4-level house with corrugated iron roof, a breeding shed, and surrounding walls to the west of the allocated land. Ms. Bui TP managed the assets of Ms. Lud Titan X and Mr. Lunak T1. The allocation of the land, assets and the dimensions has a specific diagram attached. 5. Ms. Bui TP, other name, Bui T Hung P, must repay Mr. Lunak T2 and Ms. Don TV the value of the construction on the land plot, which was 47,068,000 VND. 6. Forcing Mr. Lunak T2 and Ms. Don TV repay Ms. Bui TP, Ms. Lutitan X and Mr. Lunak T1 the value of the inheritance that Ms. P, Ms. X Besides, and Mr. T1 inherited from Mr. Lunak U and the liability for the late which was 199,319,000 VND. On October 25, 2017, Mr. Lunak T2 submitted the written request on reviewing the civil appellate judgment under the cassation procedure. At the decision number 07/QDKNGDTVC1DS dated March 28, 2017, the head of the Collegial People's Procureur in Hanoi protested against the civil appellate judgment, number 25/2017/DSBT of September 28, 2017 of the People's Court of Hungyen Province, and requests the Collegial People's Court in Hanoi to try under the cassation procedure, to cancel the aforementioned appellate judgment, and the first instance judgment number 01/2015/DSST dated March 31, 2015 of the People's Court of Fu-Siu District, Hungyen Province, and handle the case over to the People's Court of Fu-Siu District for the first instance retrial under the provisions of law. Part 4. Assessment of the Court. The Judicial Council of the Supreme People's Court finds. Based on the testimony of the parties recognized that the land area of plot number 31, actual land area was 990.2 square meters, map number 269 in Village D, Commune D1, District P, Hungyen Province was originally gifted to Mr. Lunak U by the People's Committee of Commune D1 in 1973. This land plot is currently managed and used by Mr. Lunak T2, record number 181, 184, and Mr. T2 has not obtained the certificate of land use rights. Ms. P, the daughter-in-law of Mr. Lunak U, said that after Mr. U was granted the land, Mr. U's wife and Mr. Lunak H, the son of Ms. U and her husband, brought the materials from Lang Sun to build houses and constructions on the land. Mr. U and his wife lived for a short time, then moved to Lang Sun to live with her and her husband. That house was lent by Mr. C1's family, the younger brother of Mr. U, so that Mr. T2, Mr. C1's son, could live in. Meanwhile, Mr. T2 and Ms. S, Mr. C1's wife, did not admit to borrow Mr. U's house and land. They affirmed that because Mr. C1's family had many children, no one was married and was not eligible for land allocation for residing the people, Mr. U, on behalf of Mr. C1's family, applied for the land allocation. Mr. C1 was the person who directly received the land and let Mr. T2 and his wife live on that land and presented Mr. T2's confirmation of being received the land, building construction on land to prove. Based on the witness's confirmation, it was shown in the appraisal record of Mr. T2's house bricks brought by Ms. P from Lang Son that there was a basis to determine that houses and properties on land were founded by Mr. T2's family. Regarding the disputed land, it was found that Ms. P and Mr. T2 could not provide papers proving their lawful land use right. However, based on the testimony of the involved parties and the verification minutes at the People's Committee of Commune 1, record number 253, Mr. Ta Quang H., as cadastral official of Cooperative D1 in 1960 to 1978, had the basis to determine that in 1973, Mr. Lanaku, Mr. Lanak C1's elder brother, was working in Lang Son and went back to his hometown to ask for a land, and was granted a land by the People's Committee of Commune D1. It was shown in the verification minute with the cadastral official of Commune D1 that Mr. U was the owner of the disputed land plot on the plot map in 1981 and the declaration record in 1982. Mr. Lanak T2 was the owner of the disputed land plot on the Commune cadastral map in 1998 and the declaration record in 1998, record number 37. According to the verification minutes at the People's Committee of Commune D1, the plot of land managed and used by Mr. T was given to Mr. U by the People's Committee of Commune D1 in 1973. In the name of Mr. U. It was not determined that Mr. U, under his name, asked for that land for his or Mr. T2's use. The commune had no documents related to the transfer of land use rights, but the fact was that Mr. U and Mr. H's family, Mr. U's children, did not live on this land plot. This land parcel has been managed and used by Mr. T2's family since 1975 and Mr. T2's family has paid housing and land tax, record number 253. Mr. Ta Quang H., who delivered the land to Mr. U, also confirmed that the plot of land was not used by Mr. U but by Mr. T2. Then, Mr. U asked for another land because the old plot of land was used by Mr. T2 when the cooperative granted him a second plot of land. Mr. B, Mr. T2's brother, is now using it according to record number 262. Although Mr. U was granted the land, Mr. U did not use it but allowed Mr. T2 to use it since 1975 until now. In the process of using the land, because the land was too low, Mr. C1 and Mr. T2's family had to hire people to fill the ground, build and repair houses many times. Mr. U and Mr. H both know this, but there was no dispute. The People's Committee of D1 Commune and the witnesses living in this locality determined that Mr. U and Mr. H did not live on the land and did not build a house. They sometimes visited and stayed at the house of Mr. C1 in the village. After Mr. U and his wife died, Mr. H, the only son of Mr. U, established a written commitment to confirm that Mr. U had not lived in that land. The land use rights would be assigned to Mr. T2 and the family had no opinion. Thus, Mr. U was the person granted the land but he did not use and allowed Mr. T2 to use it since 1974 until now. In the process of using the land, Mr. T2 built a house, declared and paid the house and land use tax. Thus, according to the law provisions on land, Mr. T2 was considered being granted certificate of land use rights. The fact that Mr. U did not use the land but his name was on the map number 299 and the declaration record in 1982 was incorrect and was not a basis to determine that Mr. U was the legal owner of this land. The fact that the first instance court and the appellate court, based on the allocation of land to Mr. U, determined that the disputed land was owned by Mr. U and his wife and accepted the petition of the plaintiffs and deducted for Mr. T2's effort was unlawful. On the other hand, because this case was a lawsuit on claiming property, land and compensation when the state recovered the land, this case was a case without quotas. It was illegal that the appellate court determined that the case was with quotas. Therefore, the protest of the head of the People's Collegial Procuracy in Hanoi was grounded. There were errors in the first instance court, however, these errors could be remedied in the appellate court. It is not necessary to cancel the first instance judgment to settle the case again according to the first instance procedures to avoid prolonging the resolution of the case. Part 5, Rules. Therefore, according to point A, Clause 1 of Article 337, Clause 3 of Article 343 and Clause 1 of Article 345 of the Civil Procedure Code in 2015. Decision. 1. Cancelling the Appellate Judgment Number 25/2017/DSPT dated September 28, 2017 of the People's Court of Hungyen on the case of requesting the return of house and land and compensation when the state recovers land in Hungyen Province between the petitioner Ms. Bui T.P., other name, Bui T. Hung P., Mr. Lanok T1, and Ms. Lu T. Ton X and the defendant Mr. Lanok T2. The people with related rights and obligations were Mr. Vu T.S., Ms. Don TV, Mr. Lunok C2, Ms. Tran T.N., Ms. Lu T. D1 and Ms. Lu T. D2. 2. Handing the case file over to the Hungyen People's Court for re-appellate trial according to the provisions of law. Content of the case law. Although Mr. Yu was granted the land, Mr. Yu did not use it but allowed Mr. T2 to use it since 1975 until now. In the process of using the land, because the land was too low, Mr. C1 and Mr. T2's family had to hire people to fill the ground, build and repair houses many times. Mr. Yu and Mr. H both know this, but there was no dispute. The People's Committee of D1 Commune and the witnesses living in this locality determined that Mr. Yu and Mr. H did not live on the land and did not build a house. They sometimes visited and stayed at the house of Mr. C1 in the village. After Mr. Yu and his wife died, Mr. H, the only son of Mr. Yu, established a written commitment to confirm that Mr. Yu had not lived in that land. The land use rights would be assigned to Mr. T2 and the family had no opinion. Thus, Mr. Yu was the person granted the land but he did not use and allowed Mr. T2 to use it since 1974 until now. In the process of using the land, Mr. T2 built a house, declared and paid the house and land use tax. Thus, according to the law provisions on land, Mr. T2 was considered being granted certificate of land use rights. The fact that Mr. Yu did not use the land but his name was on the map number 299 and the declaration record in 1982 was incorrect and was not a basis to determine that Mr. Yu was the legal owner of this land. The fact that the first instance court and the appellate court, based on the allocation of land to Mr. Yu, determined that the disputed land was owned by Mr. Yu and his wife and accepted the petition of the plaintiffs and deducted for Mr. T2's effort was unlawful.